Today we're joined by two members of the Cripps construction team, Iain, Benson and Nitej, Davda. Iain is a member of the firm's non-contentious construction team. He's got over 20 years experience, both as a solicitor in private practice as well as in-house for one of the UK's top 10 main contractors. And he's advised on some landmark building projects and also some major infrastructure projects. We've also got Nitej with us today. He specialises in property and construction disputes and has, again, over 20 years experience in real estate construction litigation work with clients including pension funds, REITs, other property investment vehicles, as well as family offices, amongst others. And he helps them navigate their way through disputes as they arise. Now, today we're going to be talking about supply chain insolvency and delay, two fairly gloomy topics. As you're all aware, the pandemic is over, but really the after effects of COVID combined with the current global economic and political climate are and continue really to cast a long shadow over the construction industry. This pressure cooker environment that we're operating in, and business find themselves operating in, and these ongoing political uncertainties mean really that it's inevitable that projects suffer delay, postponement, and obviously in the worst case scenario, cancellation. And this does lead or gives rise to contractual disputes, which means it's more important than ever really for parties to be proactively managing that risk. Now, it goes without saying really that the very real threat of supply chain insolvency adds insult to injury on many construction projects. And of course, it's not possible to avoid an entirely counterparty insolvency or indeed the risk of delay, but there are a few key things that you can do, and these are sort of themes that we'll come back to throughout the course of the discussion today, that construction companies can do to significantly limit the damage resulting from the occurrence of these kinds of risks. The first thing is being aware of having a general commercial awareness of the market. The second is a careful review of contractual terms and indeed technical specifications as well, and the allocation of risk before entering into contracts, and that limits exposure to price increases and delay. The third is ensuring that those who are managing their projects are fully aware of contractual obligations and their correct operation of the contract. And finally, the keeping of accurate records to evidence entitlement or to defend against a claim. And so, as I said, those are some key themes that we'll come back to over and over again today. But today, really, what we want to do in today's session is highlight some traps for the unwary, really, in the eventuality that we do come across these kinds of challenges on a project. And we're going to start with Iain, who's going to talk to us a little about insolvency. Insolvency is obviously not a new issue. It's something we've always talked about, but perhaps it's particularly pertinent at the moment. And I think, Iain, perhaps we start off by saying, why are we talking about insolvency today?
Well, firstly, the reason why we're talking about insolvency is driven by client demand. I've had a number of inquiries recently, and those inquiries continue to come in relation to contractor, particularly in supply chain insolvency. You're finding the market out there at the moment is very difficult. On our previous discussion, we talked about the difficulties of supply chain and inflationary risk. You're getting a lot more contractors that are facing financial difficulties at the moment, and that's prompting client inquiries. I mean, if you look at some of the statistics, which I looked around when I was researching the topic today, if you look at the National Statistics website, you'll see that insolvencies are at the highest level since they have been since 2009. That's in companies in England and Wales across the board, but particularly in relation to construction. In 2021, there were 2,733 insolvencies. In 2022, there were 4,332. That speaks for itself. And I think people are interested, although it is a slightly depressing subject, they are interested in insolvency because they recognise what a large and significant problem it is, particularly in relation to construction projects. If you think about, and it brings back bad memories, but if you think about the insolvency of Carillion, and particularly in relation to hospital projects where there was a JV to build a hospital in Liverpool, the number of parties that are impacted by one member of the team going insolvent is major, and it's very difficult to deal with. So it is much more of an issue on construction projects than perhaps it would be if you were acquiring a particular piece of kit or a manufactured product. So that's why we're here, and that's why we're discussing it today, as far as I'm concerned.
Yeah, I think that's a very good reason why it's so current at the moment. You've got a situation where even within your supply chain, you've got companies potentially approaching insolvency that could drag other companies under with it.
Absolutely.
In terms of a sort of factual test for insolvency, what is insolvency as far as the law is concerned? Do you want to just talk us through the sort of factual test?
Yeah, I think that this is very important, because the road to insolvency can often be a long one, and you'll find that you've got contractors or subcontractors, depending upon where it is in the supply chain, that are failing to perform. They're issuing very large payment application notices for unjustified sums. There are all kinds of indicators that things are going wrong and they're having financial problems. But in the factual definition of what insolvency is very important, because if you get it wrong and you're moving on, we'll talk about it later, but if you terminate a contract for insolvency and they're not insolvent, you've got a big problem. So the factual definition of insolvency, you need to look at section 123 of the Insolvency Act 1986, and that creates 4 criteria as to what would constitute factually an insolvency in relation to a company. We're not talking about individual bankruptcies and things like that today. So the first category would be if a creditor is owed by a company let's say £750, and then you serve a demand for that money on a particular prescribed form, and that the debtor is unable to pay it within 3 weeks. So that's one criteria. The second criteria, and they are all mutually exclusive, they stand alone, is that the court has issued a judgment or decree or order in favour of a creditor, and that order isn't satisfied in all or in part, i.e. isn't paid. So you've got a judgment debt that isn't paid. The next criteria is that it's proved to the satisfaction of the court that the company is unable to pay its debts when they fall due. And then the final category is that the company is unable to pay its debts because its debts outweigh its liabilities outweigh the money that is coming into the company, and therefore it is technically insolvent. So they are the 4 separate criteria factually that you're looking for as a test to whether a company is or isn't insolvent. And if you've got an answer to yes to any of those, then you're looking in the realms of insolvency.
So we've got a sort of building blocks in place. We know what insolvency is, and we know why it's a serious risk for construction projects.
Yeah.
I suspect that everyone who's joined us today will want to know what can be done at the outset or at the planning stage really of a project by a prudent employer to address potential risk, in the project going forward.
Yeah, I mean, I'm laughing. Well, I'm laughing because I sit here at the start of transactions with developer clients, and everybody's very positive, and they all say it's all going to work out brilliantly, and there's no problems. And I'm always seen as the most negative person in the room because I'm always going, what if? What's going to happen? But it's important at that early preparation stage to take a very realistic view and hard-nosed view of the project. And you can protect yourself a great deal by doing appropriate due diligence at the procurement stage when you're going and interviewing potential contractors as to who you're going to use. At the invitation to tender stage, you need to do your due diligence with the contractor, their financial background. You need to also look at your professional team, the people that are going to manage that contract. So the contract administrator, the project manager, you want to be confident that they can manage difficult scenarios and that they are financially sound. Because if the worst does happen and you do encounter supply chain insolvency, you're going to want people that know what they're doing. In addition, you're going to want ideally to be asking at the outset to the contractor to provide a performance bond in the event of insolvency. You're going to want to ask the contractor, depending upon their corporate structure, whether they can provide a parent company guarantee, guaranteeing their obligations under the building contract. If you're making substantial advance payments for particular pieces of kit, for example, in China or lifts in Switzerland or something along those lines, then you're going to want to consider perhaps advance payment bonds. So the money that you're paying out early is protected in the event of contractor insolvency. You can also tweak when you submit your building contract on the invitation to tender, you can issue a schedule of amendments. Lawyers always bang on about these, but they can offer you a material advantage where you tweak the risk to the developer, to the employer in that building contract. And looking at your project, you can also think about whether it would be appropriate to structure it into sections, which would be useful because if you've got several blocks, it would be better if you control the sequencing so the contractor, if they go insolvent, they're halfway through one block, not halfway through 5, and then you've got to complete the building of that. So there are lots of things that you can do there.
And in terms of, I mean, you touched on performance security, we'll talk a little bit about it in further detail now. Performance bonds, parent company guarantees, it seems to be an area where people say, oh, should I have one or the other? Can I have both? There's a bit of confusion about what each of them do and why. I think probably in terms of performance bonds, the ABI bond is probably the one that most people haven't heard about. Should we talk a little bit about performance bonds first?
Yeah, absolutely. Performance bonds are fine. So in my view, you should always be asking for a performance bond from your contractor, because you'll be looking at the situation. Can you afford this contractor to go insolvent, and who should pay for the risk? So you would ask the contractor to provide a performance bond. You would note on the contract particulars, I think you can say apply, doesn't apply, and the contract particulars, I think it's something like clause 7.3.1 or something like that. And you get prescribed form of bond. Everybody understands the terms of the bond. It's the Association of British Insurers form of bond. It's a performance bond, it isn't an on-demand bond. So you just got to bear in mind, and we'll come on to that later, but it will only pay out in the event that there's been a breach of the contract. And the losses are established and ascertained in accordance with that contract. So you would ask for an ABI bond. That schedule of amendments that I was talking about that your solicitor should prepare should annex the ABI bond to the back of it, but we would tweak it normally to make it very clear that insolvency is a breach of the contract. There's various reasons why that is or isn't a good idea. It's quite complicated. Obviously, a performance bond will pay out in the event of insolvency, but it's certain triggers and when you get entitled to recover the money that's quite useful. So, yeah, ask for an ABI bond, mark up the contract to that effect, tweak the ABI bond in the schedule of amendments to the contract so it mirrors what you want to achieve and creates earlier triggers to recovery of money. That's pretty much it.
And just to be clear, you mentioned JCT contract particulars, clause references. That was in relation to the standard building contract. Just to be clear for everyone today, where we talk about standard building contract JCT, the suite applies equally to the design and build contract as well, but we will just focus on the standard building contract today for the sake of ease, really, but just so that everyone's aware, same provisions apply across the board in the design and build as well with slightly different references. Let's move on and talk about parent company guarantees. As you say, the most helpful situation is to have both the bond and the parent company guarantee, but there are certain, as with the bond, there are certain things that you need to consider in relation to a PCG as well.
Yeah, this is quite funny. You will, at that tender stage, you will get kickback from the contractor saying we can provide you with a parent company guarantee or a bond, but not both. I mean, I've sat there with internal governance memos for a main contractor saying offer one or the other, don't offer both. You should ask for both, and there's very good reasons why you should ask for both. A performance bond, and I should have said this earlier, will cover 10% of the contract sum. It will not cover the whole liability of the contract. A parent company guarantee, the guarantee will cover all of the subsidiaries' obligations under the contract. So in that respect, it's quite useful because it will cover all of those obligations. The other thing is that you can put in things in a parent company guarantee which are very useful, like primary obliger obligations. So it will make the parent company obliged to complete the works. It's not just recovery of a financial sum, it's an obligation to carry out the works. Now, one of the arguments that you often get back is, well, why do you want a parent company guarantee? Because frankly, if the bond is triggered for insolvency, then the parent company's probably gone bust as well. But in practice, even if you haven't got an insolvency event and the subsidiary is struggling, the good news is that that notice that you will serve under the parent company guarantee to the parent will put the parent company and the directors potentially of the PLC on notice that their subsidiary is failing to perform. So if they're not going insolvent and they're just failing to perform, trust me, they will pick up the phone on the directorship board and then speak to the director of the subsidiary company, and I'll start asking what's going on. So it's got useful additional tools there in a PCG.
Yeah, and you mentioned the PLC, that is a very good case scenario. The slight issue that we come across in contractors with regards to parent company guarantees is that you've got to look very carefully at the parent company itself, just as you do your due diligence in respect of the construction team you put in place at the outset of your project, as Iain mentioned. A parent company guarantee isn't worth the paper it's written on if it's given by a shell company with no sort of financial covenant.
That's going back to those schedules. I can't repeat it enough. People always say, well, why am I paying for my lawyer to negotiate this schedule of amendments? Because this is in the schedule of amendments as well. The parent company guarantee will be provided by the ultimate parent company. Because you often get situations where they'll offer an intermediate parent that is a shell company, as you say, but no, to protect the parent. So that's the kind of thing that can certainly help you as an employer in advance in preparing for eventualities that you hope will never happen. But sometimes they do. The frequency is increasing, as we say.
Let's move on and talk a little bit about retention. Cash is king. People love retaining funds. That seems to be a very comfortable position for companies to be in. Why are retentions helpful in the event of insolvency?
Retentions are helpful because it's money as an employer that you're holding, and money in your pocket rather than in the contractors in the event that the contractor is likely to default is always useful. In terms of retention, the purpose of retention when you select it, and you do need to select it on the contract particulars and say the amounts of the retention that you will hold, it's normally 5% of the contract sum. Part of it repayable on PC and then part of it repayable when you issue the certificate of making good 12 months later. But the useful thing is, if it's in respect of defects, you hold on to that money until the defects are corrected and then you pay it back to the contractor. If the contractor is insolvent, and once again, if you tweak the JCT provisions by an appropriately drafted schedule of amendments to reduce fiduciary obligations, then you can use that money that you're holding as a retention to set off against the losses that you will incur in the event that the contractor goes insolvent, because you're going to have to go and get somebody else to finish off the job. So that's what you do. Just to make it clear, when I'm talking about fiduciary duty, if you don't tweak the JCT contract obligations, you're holding, you the employer, holding that money as trustee for the contractor. It's their money. You need to amend that, and that's what we do, to say that you're holding it for you, and therefore you can set off that money and take it back in the event of contractor insolvency.
Now, a little bit earlier on, you mentioned collateral warranties with step-in rights can be a particularly useful tool. Should we cover that briefly now?
Yeah, no problem. I mean, the collateral warranty point is that the JCT standard form provides for, as long as you select in the relevant contract particulars or the relevant recital, I can't recall which, but if as long as you select that you are to provide collateral warranties, what you will arrange is for the subcontractor supply chain to provide collateral warranties for you as the benefit of the employer. Now, the JCT standard form, I think it says CWA/E, anyway, it doesn't matter. It contains step-in rights. Those step-in rights can be triggered, so you as the employer can step into the contract with the subcontractor and ask the subcontractor to perform it in the event that the main contractor has gone insolvent. Now, that is invaluable when you've basically got a main contractor that has gone off deck, if you like, and is no longer to be found and is no longer performing the contract. You're thinking, who's left to perform this contract? And if you've got those step-in rights, at least you've got all of the subbies to continue to work, and then you can pay them directly. Or you can interpose a new main contractor in place of the insolvent contractor into that chain. But the whole process can still operate. That's the idea.
And it's not an unusual position to be in on a construction project where your subbies are the ones with the big financial covenant behind them. They are the big construction companies.
Yeah, absolutely. I mean, if you think of piling contractors, lift installation works, all of that kind of thing. I mean, to be honest with you, main contractors most of the time are picking up most of the risk and acting in a project management kind of role. They're nice to do it work. So
you've got a good covenant there with your subbies, provided that you've got that protection that you just mentioned. So in practice, what can your legal advisors do at the pre-contract stage to help mitigate an employer's risk of main contractor insolvency? We've touched on some of the provisions already, but
yeah, sorry, I'm moving around a little bit. We tweak the schedule amendments. It really is an invaluable tool. A lot of people just think, oh, it's 30 pages stuck to the back of the JCT contract that everybody moans about, nobody knows what's in there. But you tweak the JCT by the schedule amendments, and you can put useful things in, like in the termination provisions on a JCT contract. It's quite formulaic what insolvency is defined as, and you could perhaps put in there a termination provision, which we often do, that allows you to terminate in the event that a petition is issued in respect of a recovery of a debt and isn't set aside within a week or 2 weeks of the petition for the outstanding debt being served at the insolvency courts. That's very useful because there's a lot of ambiguity in that period when a contractor isn't performing as to whether they are or they're not insolvent. So you up the ante and give yourself the opportunity to terminate when it's more financial difficulties rather than actual court orders being issued, etc. You can also put in sectional completion. I talked about earlier also retentions and removing that fiduciary obligation so that you can get a hold of and set off the retention monies in the event of insolvency. This is a really nice one if you can actually get it negotiated, is that you would amend the schedule of amendments to allow for the money so that you lose in the event of the contractor insolvency to be estimated at the time of insolvency so that you can actually recover the money there. The problem with the JCT contract is that you can only recover the money for insolvency when the final account is issued, which is after the certificate of making good defects is done. So you want to get hold of your money early. You want to amend the schedule of amendments to say, hold on here, I mean, the contractor's insolvent, in which case we, the employer, can create a realistic estimate of what that loss is going to be as a consequence. It's recoverable as a debt and we'd like it now. And then you can waive it in front of the bondsman and say, can I have my money, please? So those are the kind of changes that you can tweak.
Presumably, you would also look at, as well as looking at circumstances where you can make it easier to recover money once you've spent it.
Yeah.
Other provisions that you could look at would include retaining additional sums if things aren't done. So, for example, procurement of collateral warranties,
exactly,
or parent company guarantees, etc.
Yeah, I mean, I can't say this enough. Don't give the contractor or any of the supply chain an easy ride on providing you with collateral warranties. Nitej will know it, we all know it. There's a contractual obligation that we can put in the schedule of amendments that says that the employer can withhold money in the event that the contractor or subcontractors don't provide these collateral warranties. The collateral warranties are important for many reasons, but one of the most obvious one is those stepping rights that we were talking about earlier. And withhold the money if they don't come up with a collateral warranty. Because when the worst case scenario happens, you ain't going to get the collateral warranty when they're facing insolvency. They're looking at a lot of other people that they need to keep happy, particularly probably the revenue, because that's normally the people that are making people insolvent when you own taxes. You want to make sure that that's done early, and as Nitej says, you can tweak the contract to make it clear that you withhold part of a payment valuation in the event that these warranties aren't provided.
Moving away from the legals to the real world again, even your most wonderfully drafted schedule of amendments and your most perfect suite of contract documentation sometimes can't get you around a situation where the worst happens and you suspect that your main contractor is encountering financial difficulties or at least approaching insolvency. Very briefly, what are the do's in that side of situation, or perhaps more relevant, what are the don'ts?
Okay. When I was talking earlier, I think I was talking about the importance at the outset of making sure that you've got the right team on board, both in terms of the contractor, but also in terms of the professional team, the project manager and the contract administrator. They are the people that are going to steer you through this and advise you in the event that you're facing a contract with financial difficulties or potential insolvency. So you want to speak to them and see how they think would be the best way to plan this disruptive event for your project. And the reason why you want to speak to them is because not all projects are the same. The response is not all the same. If you've got a contractor that's gone insolvent for something totally unrelated to your project, and they've only just put, you know, boots on the ground and a shovel in, and it's 5% done, then the answer would be perhaps yes, you want to terminate for insolvency. If you're 95% or 90% of the way through your project, your contract administrator with the appropriate experience might be turning around and saying to you, perhaps we let this contractor limp on. What can we do to help this process? Perhaps we can enter into a deed of variation to the building contract to allow them for additional money, because even if you might begrudge paying them more money, it might be cheaper in the long run than instructing another contractor. So those are the kind of things that you need to do. You need to also make sure that you've got all your paperwork ready. Make sure that that bond isn't due to expire, unlikely, because it will normally expire on PC. Make sure that you've got your parent company guarantee there. Make sure you've got your collateral warranties. And have the conversations early if you think that there's a risk. Even if you're not sure, if you're a bit doubtful, start getting all of this paperwork ready. You might also need to start speaking to your funder and explaining to them what's going on, because you might have funder agreements, etc., which will require you to respond in a particular way. So, last one, go down and audit the site. See what's there, see what's yours, because I can assure you, when a contractor encounters financial difficulties, it's amazing what things start wandering from site that you've actually paid for.
So those are the do's, and the don't is probably don't panic.
Yeah, Corporal Jones, isn't it? To Captain Manwaring, don't panic, don't panic. Yeah, it is very important not to panic. And the most important panic is not to do is don't just get the contract out yourself, read it yourself and go, oh, right, well, we think that they're insolvent, let's terminate. I'll go and have a look at the termination provisions and we'll serve a termination notice. If you get it wrong, and we were talking about the factual criteria for termination earlier under section 123 of the Insolvency Act, if you get it wrong, because you've not worked that out in comparison to the termination provisions in the contract, the criteria for insolvency at clause 8.1, then you could potentially land yourselves in the realm of a repudiatory breach, where you've breached the contract, and then the contractor, who would be unable to perform this contract anyway, comes to you and says, oh yes, we were able to perform it, you know full well that they couldn't, and say, well, we've lost our profit, we've lost this contract as a result of you, why did you terminate? The criteria for termination wasn't met. So don't panic, take things slowly, take professional advice, speak to your contract administrator and your project manager, and then move on from there.
And in terms of moving on, just to wrap up this insolvency section, I'm conscious of time. In the event that you have got a situation where you move towards termination, what are the steps? What are the termination mechanics, as it were, in your contract? Yeah, so I mean, it is fairly straightforward in the sense that you go to the contract, you go to clause 8.1, you look at the criteria for insolvency there. So you're going to need a contractor who has entered into administration. If the contractor has had an administrative receiver appointed, if the company passes a voluntary resolution to wind it up, or a winding up order is made against it, then you've got an insolvent contractor. If you've got an insolvent contractor under clause 8.1, you turn to clause 8.5.1 and you realise that you can serve a notice on that contractor with immediate effect, terminating their employment. Once again, can't highlight it any more important than this. Make sure that the notice is correct. Make sure that you've taken legal advice on it, because you need to comply
always check and comply with the terms of the contract, because if you don't, you'll end up potentially in a very sticky place. You issue a pay less notice straight away in the event of financial insolvency to protect you, and you secure the site.
And taking that just one step further, you've taken your legal advice, you've terminated your contract, following good practice as we just discussed. You've got a new contractor in place to finish off the project, who likely, in all likelihood, is charging you a lot more than the original contract price in order to pick up and take things forward from where you've got to. Can you recover any of that loss?
Best of British luck, frankly. This is why I said at the outset that you basically need to make sure that you've got a bond or a retention. Because if you don't have a bond or a retention, you're an unsecured creditor. You need to file a notice of debt in the insolvency proceedings because you're owed money, but frankly, you're an unsecured creditor. You're not going to get the money back. The only time that, and in terms of when you get the money back, you're going to have to potentially wait for it as well. As I said, if we don't tweak the contract, the debt becomes due on an insolvency when the final account is due. Because what you're entitled to recover is the difference between the contract sum that would have been paid out and what you've actually ended up paying out because of the additional cost of instructing somebody else to do it. But that is an unsecured creditor situation. So if you haven't got a bond to call upon and you haven't got retention money to deduct, unlikely.
Yeah, thank you, and I think that's a really good summary of insolvency in the context of construction projects, and it is this difficult area where the law is very difficult, but actually in practice it's something that everyone grapples with, and as you said, it's something that we're seeing a huge amount at the moment. So it really is a very live issue for everyone, a live concern at least for everyone. Moving on to talk about delay, and obviously as we put in the chat there, please do, if you've got any questions as we go along, please do put them in the chat. We will pick them up at the end. So if you've got any questions for Iain, then please do put them in the chat. Moving on, Nitej, to talk about delay. And we all know in the English language what delay means: late, non-delivery. What does it actually mean in the context of in the construction context?
Thanks, Chrissy. Well, delay is not a novel concept in and of itself, and it is pretty much what you've described. Save in a scenario where time is at large under a construction contract, which we don't need to be concerned with purposes of today, contracts will dictate a date by which the works or a section, if your contract dictates sectional completion, contracts will dictate a date by which that work has to be completed by, and a failure to deliver the project or the section by that date is a breach, and a breach has consequences. So delay in the context of a construction project requires consideration of two things. Well, actually, it only requires consideration of one, but it's in two parts. Firstly, what are the contractual provisions that are relevant to delay? And secondly, what are the contractual provisions which identify the consequences of a delay? So, as we've talked about, and as Iain's talked about in the context of insolvency, the contract is very much your starting point.
And this is sort of where we start moving into the realms of something that's sort of unique in a way to construction contracts, which is this idea of extensions of time. So you've got a delay, but what is the reason for the delay, and how do we deal with that within the construction contract itself or the framework? Do you want to just briefly talk a little bit about extension time before we move on to relevant events? And
Well, again, we were looking in the insolvency section. We were looking at the standard building contract and the JCT suite. So let's just use that for consistency. You've got the general obligation in clause 2.1, which is the obligation to undertake the work in a proper workmanlike manner. That's helpful, but it's not so relevant to delay. What's more relevant to delay is clause 2.4. Clause 2.4 is the obligation to deliver, to diligently proceed and to deliver the project by the contractual completion date, and in the termination provisions in the standard form, the unamended standard building contract, and indeed all of the JCT suites of contracts other than the minor works agreement, a breach of clause 2.4 is a specific reason for termination. You've also got an obligation as a contractor. You've got an obligation to deliver to notify the employer of delays, and that applies irrespective of whether there is an extension of time application or there is a loss of expense claim. So that applies independently of whether there is a relevant event or a relevant matter. I suppose that probably then leads on to your next point, which is really starting to look at those concepts.
Yes, I mean, I think the key really is for everyone to be clear about what a relevant event is, what a relevant matter is, and what the difference is really between the two, in terms of the impact that it has on running your project and operating under your contract. So should we start? Do you want to start with relevant events?
Yeah,
the most suitable place to start.
Well, I think it's probably taking a step back from that slightly and looking at allocation of risk more generally under a construction contract. Under any construction contract, there will be certain things that are allocated as employer risks and certain things that are allocated as contractor risks. So relevant events, those that are familiar with JCT suite of contracts, for example, will be familiar with the list of relevant events. Those are circumstances that arise that may give a contractor the entitlement to an extension of time. That's an employer risk. A relevant matter, again, they're identified in the contract itself. Events that comprise relevant matters may give a contractor entitlement to more money. That's another employer risk. Now, there may also be specified contractor risks. The liability for unforeseen ground conditions may be allocated to contractor risks specifically in the contract. You've got the provisions in the contract concerning defects during the construction phase and pre-PC. You've got the provisions which entitle the CA, the contract administrator, to require opening up work to examine what's there, and if there are defects, and the contractor has to remedy and meet all the costs and be responsible for the time associated with that. That's another specific allocated contractor risk under the contract. Of course, not all risks are provided for explicitly, and if your contract is silent, then you may ask, well, who's responsible? I think the starting point is that if the contract is silent, then the risk that arises that isn't provided for in the contract should be seen as being a contractor risk event.
And we move away from the pure legals really into the realms of identifying the true cause and effect of a delay, and into this concept of delay analysis. And before we talk about the importance of the critical path, should we just cover off what essentially what delay analysis is?
Yeah, well, I think there are three principles that we look at when we're considering delay. If a relevant event alone causes delay, then a contractor is entitled to more time. A relevant event can also be a relevant matter, but not always. A variation, for example, a variation instruction is described in the standard form of JCT contract as both a relevant event and a relevant matter. So if something is a relevant event and a relevant matter, then it's both a relevant event and a relevant matter, then it may entitle a contractor to more time and also more money. But not all relevant events are also relevant matters. So, for example, adverse weather. Adverse weather will, in the unamended form of JCT contract, will give rise to an entitlement to more time. It's not a relevant matter. So there's no entitlement to more money that flows as a direct result of that. But if delay isn't down to a relevant event, then it's a contractor risk. And so the consequences of the contractor delivering late without excuse or without an entitlement to an extension of time is its exposure to liquidated damages, assuming that liquidated damages are provided for in the contract, which they almost certainly will be.
And when we're talking about delay analysis, the key thing really is what's referred to as the critical path. Everyone's aware. I mean, the layperson is aware that every construction project obviously has a start, a middle, and an end. But the analysis of that critical path and how things happen and when they need to happen and what happens first and what happens next and what potentially can happen at the same time is really crucial in establishing a delay situation.
As you say, every construction project has a start, middle, and an end. And the constituent ingredients of a project are are the necessary activities. So we can look at we'll look at a basic example in a moment, but the critical path, just coming back to that, that's the combination of all of those steps, all of those construction steps, those construction activities, which determine or define the length of a project. So if you use the example of a house, pretty straightforward scenario. There are certain elements of that construction phase, of that project, that we know have to happen in a certain sequence. Foundations come before your above ground construction, your above ground construction, the walls come before the roof, etc., etc. The internal fit out is the last piece of the puzzle. There are certain elements of that have to happen in a certain sequence, so you can't do the roof before you've constructed the walls. You could do, but it's going to be a bit of a disaster. But there are other elements that can run in parallel. So, for example, your fit out of your bedrooms can take place at the same time as your fit out of your bathrooms. And if your those elements don't impact on the overall timeline, i.e. they can run in parallel to other elements, and they're not the last thing to be finished, they're not the topping out things, then they're not critical. So your critical path is the sum total of those activities that have to happen in a certain sequence in order to deliver your final product. In the example of a house, it's pretty simple, but most projects are not quite as simple as that. And the more complex the project, the more potential methods of undertaking the project works may exist. And that may result in there being alternative critical paths, reflecting the different methods of sequencing. Now, your contract may dictate or constrain a contractor as to how they can deliver a project. For example, you've got section completion. Section 1 can't be completed before section 2, section 2 can't be commenced before section 1 is completed, section 3 can't be commenced before section 2 is completed, etc., etc. And that will constrain the number of variables that go into your critical path. The subject of that is the more complicated and more involved a construction project is, the more alternative methods there are of completing it, and therefore the more alternative critical paths you may have.
And that's complicated enough as it is, but then we move into the world of concurrent delay, which is where things get particularly difficult, potentially particularly litigious.
If we come back to delay analysis first, we'll come back to concurrent delay, because of course the critical path is your theoretical assessment of how a project is sequenced all the way through to completion. The question of delay involves delay analysis. Now that, I think Iain knows from his experience working in the house.
That's a very profitable business, delay analysis, and certainly when I was a counsel trial, I spent a lot of money on delay analysis. But it's an industry in itself, as Iain hints at, and you can often say that if you get 2 lawyers or 2 accountants in the room, you get 3 answers. There are not many other professions where that might happen, but delay analysis is potentially one of them. And I say that at the risk of offending anybody that's in the audience that is a delay analyst. But delay analysis essentially is the exercise of piecing together the critical path, identifying potential events of delay, and then reaching an opinion on the impact of those events on time. And then as part of that process, you identify, when looking at those potential events of delay, which ones are employer risks and which ones are contractor risks. And then you end up in a scenario where you've identified both the period of delay, the causes of those periods of delay, those individual slices of delay, and who is responsible for which of those slices, in order to then allocate the risk and identify the remedies accordingly. So there are a number of different methods of undertaking that exercise, which is where the comment about different conclusions comes from. Now, the Society of Construction Laws Delay and Disruption Protocol, I think, identifies half a dozen different methods. And which one's relevant and which one's appropriate depends on a number of factors. What does your contract say? Does it prescribe how delay is to be analysed? Timing, when is the assessment being undertaken? Is it being undertaken in real time as the delay event has occurred?
or is it a retrospective analysis being carried out after the project is completed, and you're trying to work out the impact of an event that occurred 12 months ago? What's the project type? More complex projects may require a different approach to delay analysis than more straightforward and simple projects. For example, projects involving chemical engineering plants may well have a very, very different method of delay analysis, because the impact of certain events on delays is viewed differently than in a more straightforward or house building project, simple house building projects, if you would. Proportionality, both in terms of time, how long have you got to undertake this analysis, and cost. If you've got, I mean, I've been involved in cases where the cost of the delay analysis report has run into six figures, significant numbers. But in a project of the size that we were dealing with, it was actually not disproportionate. Now, if you're talking about a project where the contract sum is £3.5 million, then a delay analysis that's going to cost you £150,000 is significantly more questionable in terms of an investment in expenditure, and is there a more straightforward and simple and more cost-effective way of analysing delay? But also, and perhaps most important of all, the quality of the information that you have to work with, because the better the quality of information, the more comprehensive it is. The less gap, the fewer the gaps are that you then have to make assumptions about, or just take a little bit of a leap of faith with, because that's where your variances in approach will come from.
Yeah, I think I remember Marcus in the previous construction seminar, three things to learn: importance of records, the importance of records, the importance of records. That's just a running theme throughout, really. I am going to make you talk about concurrent delay.
I try to avoid it, but there we go.
Can't riddle this time.
No.
So it is obviously often deployed as a defence, whether to an employer's claim for LADs or to a contractor's loss of expense claim. It is really important for you to be clear on what concurrent delay actually is, or perhaps you'd argue what it's not. I think should we conclude the delay section just with a bit of discussion around concurrent delay?
Yeah, well, you're absolutely right that it's perhaps more often deployed than it actually exists, because it's quite an easy hook to hang a defence off. So put it in its most simple, concurrent delay is two things happening. One being a relevant event, so an employer risk. The other not, so contractor risk, either of which, had they occurred on their own, would cause delay. But this is the critical point. The effect of each of the risk events must be felt at the same time. So the impact of your contractor risk event and your employer risk event must be felt at the same time in order for your delay to be treated as purely concurrent delay. Because if it's not, then the impact of each can be segregated and separately assessed. And so you can then analyse what's the impact of the contractor delay, what's the impact of the employer delay. So concurrent delay is quite often used, but perhaps slightly less common than people think. What then happens is you have to then turn to considering what the impact is. Now, Iain will tell you that in most Iain's talks about schedules of amendments to building contracts, and I think it's fair to say that
I'm putting an amendment in straight away. I can't emphasise this enough. Go back to your schedule amendments, see a non-contentious lawyer before you get here in the first place, who will simply write in: the contractor is not entitled to time and money for events of concurrent delay. And that's a lot cheaper than going to see detention, which litigators over there.
You've still got to then establish that there is concurrent delay, of course. But,
yes, of course.
But you're right that the standard form building contract, the JCT suite of contracts unamended, don't provide concurrent delay specifically. So it's something that you can find in a schedule of amendments. If you are working with a contract that doesn't have an amendment to deal with concurrent delay, then your question would be, well, what's the effect if you do establish that there is concurrent delay? The short answer is time but no money. The contractor is entitled to an extension of time. The employer is not entitled to liquidated damages because the contractor has got an extension of time, but the contractor is not entitled to any more money either. Now, there's a convoluted legal analysis as to why that why it is time but no money. But given we are approaching almost 1:30, and I dare say that people do not want to hear me talk about the legal history of the current delay, I won't say anything more about it.
Thanks, Nitej. I think there's so much food for thought there. I mean, I think the two key takeaways really are get your ducks in a row from the outset. A well-drafted schedule of amendments, helps hugely, and then from Nitej's perspective, the importance of records, make sure everything is there because it makes it a lot easier to take things forward when things go wrong if you've got a paper trail to rely on.